Henry Brisbane. In the summer of 1973, a young man began forcing cars off a lonely stretch of Illinois interstate, one after another, robbing the people inside and leaving them behind. He was 17 years old, too young for the state to ever send to the death chamber, which is why a judge eventually handed him a sentence no one in Illinois history had ever received. Up to 3,000 years. And yet, 5 years into serving it, he would take another life without ever setting foot outside his cell block. The man was Henry Brisbane, born in Chicago on January 12, 1956, the third of 13 children. By his own account, later in life, he grew up learning to distrust nearly everyone around him, and concluded somewhere along the way that he simply did not like people. By his teens, that hardness had already turned into something dangerous. In the early morning hours of June 3, 1973, it spilled onto Interstate 57 in the southern reaches of Cook County. Brisbane used his own vehicle to run other cars off the road, then walked up to the stranded drivers on foot. One of them was Betty Lou Harmon, 29 years old, from the suburb of Darien. Another stop that same night left a young engaged couple dead on the shoulder of the highway, moments after being told to say their last goodbyes to each other. Between the 3 lives he took and the 2 robberies he committed along that road, the entire haul came to $54, 2 watches, an engagement ring, and a wedding band. 3 people were gone for almost nothing at all. Here the case ran into a wall that shaped everything that came after. In the years between 1972 and 1977, the death penalty had been struck down across the country and not yet restored, and Brisbane had been only 17 when the crimes on the interstate occurred. Execution was simply not available to the state. So in 1978, Cook County Judge James Bailey reached for the only measure that felt proportionate to what had happened and sentenced Brisbane to 1,000 to 3,000 years in prison. At the time, it was the longest sentence for such crimes in the history of Illinois. On paper, he would never walk free. The judge told the courtroom, in effect, that he was making certain of it. Most men handed a number that large would vanish into it quietly. Brisbane did the opposite. What does a prison do with a man who has already been given 3,000 years and believes he has nothing left to lose? It found out the hard way. On October 19, 1978, while being held at Stateville, Brisbane took the life of a fellow inmate named Richard Morgan, using a handle he had sharpened after breaking it off a soup ladle. This time, there was no legal shelter waiting for him. The death penalty had been reinstated in the years since his first crimes, and so Brisbane was tried in Will County, where prosecutors argued that a man who could take a life while already serving 3,000 years had proven there was no punishment left but death. On February 24, 1982, the court agreed and sentenced him to die. That date is worth pausing on, because it has been misread ever since as the day he died. In truth, he did not die that day at all. It was simply the day the state decided he should, and the confusion between the two has trailed his name ever since. What followed was more than 2 decades of appeals. In 1985, the Illinois Supreme Court upheld his conviction, but vacated the death sentence, pointing to misconduct by the prosecution. He was sentenced to death a second time, and in 1989, that sentence was affirmed. The United States Supreme Court declined to take up the case, and a later petition challenging his conviction was dismissed in 1995. Through all of it, Brisbane kept his reputation as one of the most feared men inside the state's prisons. Prosecutors tied him to more than 15 assaults on inmates and guards, a role in a prison riot, and an incident in which he struck a warden with a broom handle. In February of 1983, he even managed to reach the notorious John Wayne Gacy, stabbing him during a confrontation at Pontiac. To the officers who worked those cell blocks, he was a constant and unpredictable danger. Then the ground shifted entirely. On January 11, 2003, Governor George Ryan, in his final days in office, commuted the sentences of every person on the state's death row, 167 people in all. Most had their sentences reduced to life without the possibility of parole, and Brisbane was among them. The decision was one of the most sweeping acts of clemency in American history, and it drew fierce anger from families who had waited decades for a different ending. Brisbane, a man who had taken a life even while already condemned, became one of the most cited arguments against what the governor had done. But the governor's stated reasoning cut the other way. Ryan had grown convinced that the system itself could not be trusted with a punishment that could never be undone, after Illinois had freed a striking number of condemned men whose convictions later collapsed. It is a thread worth holding on to, because the same doubt about who really belonged on death row would return in the most literal way possible later in this story. Brisbane himself was folded into the general prison population and, in time, held at Menard Correctional Center in Chester, the facility whose condemned unit had long housed the men Illinois had sentenced to die. As for where he is now, the honest answer takes some care. For years, various accounts have claimed Brisbane died behind bars, often pointing to a supposed incident in 2018. But those reports appear to confuse his case with the death of a different inmate, a man named Fabian Carrillo, whose life was taken by his own cellmate in 2014. As of the most recent public records available, Henry Brisbane remains listed in the custody of the Illinois Department of Corrections, and no verified notice of his death has surfaced. He is credited with taking 4 lives, and was suspected in 2 more he was never tried for. Brisbane's crimes stretched across highways and prison yards, the work of a man who could turn almost any place into a scene. But not every name that ended up behind Menard's walls roamed so widely. Some never left a single cluster of city blocks, and in one Chicago neighborhood, a string of quiet disappearances would go unconnected for far too long. Hubert Gerald's. For a stretch of the mid-1990s, women were disappearing from the same few blocks of Chicago's Englewood neighborhood, and for a long time no one connected them to a single person. The man responsible was described in court as having the mind of a young child, and he would eventually confess to the crimes. But one of the deaths pinned on him did not belong to him at all, and the real answer would not surface for years. His name was Hubert Geralds, born on November 13, 1964. His early life was marked by abandonment and mistreatment. His father was gone, and a boyfriend of his mother's abused him during childhood. By the time his case reached a courtroom, defense experts placed his measured intelligence at roughly 73 and argued he functioned mentally like a much younger person. That limitation would sit at the center of everything that came later, but it did nothing to soften the pattern investigators eventually uncovered. Between December of 1994 and June of 1995, Geralds took the lives of 5 women in Englewood: Doretha Withers, Alonda Tart, Joyce Wilson, Millicent Jones, and Mary Blackman. They were women who struggled with addiction and worked the streets of the neighborhood, people whose absences drew far less alarm than they should have. He drew them in with the promise of drugs before ending their lives, in one case using a chokehold. He was also charged in connection with an attack on a woman who survived her encounter with him and could describe what had happened. For a while, the deaths read as scattered tragedies in a part of the city that too often went overlooked. What finally tied them together was closer to home than anyone expected. Part of what let the pattern run so long was the neighborhood itself. Englewood in those years was a place where a woman living hard could drop out of sight for weeks before anyone official took notice, and the cases were scattered across enough time that no single detective was looking at all of them at once. That gap between the deaths and the discovery is the reason a killer could keep returning to the same corners without ever tripping an alarm. The break came on June 18, 1995, and it came from inside his own family. His sister discovered the body of Mary Blackman at the family residence and did the hardest thing imaginable, contacting the authorities and turning in her own brother. Gerald's was arrested, and the investigation that followed connected him to the other deaths across the neighborhood. Detectives now had a suspect, a location, and a victim found where he lived. What they did not yet have was the whole truth, because one of the cases they were about to close belonged to someone else. How do you weigh a confession from a man the court has decided has the mind of a child? That question would shadow his case for the rest of it. On November 14, 1997, a jury convicted Gerald's in the deaths of 6 women, and on January 9, 1998, Judge Michael Tooman sentenced him to death. He was admitted to Menard's condemned unit a week later. For a time, the case looked closed, another serial predator taken off the streets and delivered to death row. Then science reopened it. On February 10, 2000, one of his 6 convictions was vacated after DNA evidence tied that particular death, that of a young woman named Rhonda King, to an entirely different man, a serial killer whose own confession matched the physical evidence. Gerald's re-entered a plea of guilty to the remaining 5 deaths and stayed on death row. But the reversal was a stark reminder of how fragile some of these cases were, and how easily the wrong name could be attached to a victim, especially when the accused would confess to almost anything put in front of him. The correction carried a darker implication that is easy to miss. For the King case to belong to someone else, it meant that in the same neighborhood, in the same span of years, hunting the same overlooked and vulnerable women, more than one predator had been at work at the same time. At least 2 separate predators had been working the streets of Englewood at the same time, their crimes so similar that the justice system had briefly credited one man's victim to the other. That overlap is exactly why these cases were so difficult to untangle, and why a single reversal could ripple outward for years. 3 years later, his sentence changed along with everyone else's. On January 11, 2003, Governor Ryan's blanket clemency swept Gerald's death sentence into life without the possibility of parole. The intellectual disability his lawyers had raised at trial, the very issue courts across the country were then wrestling with in capital cases, no longer decided his fate. The governor's clemency did that instead. Whether a man of his measured capacity should ever have faced execution in the first place became a question the state would never have to answer. As of today, Hubert Gerald's remains alive and incarcerated at Menard, serving life without parole. In a strange turn for a man who once admitted to the crimes, he has since insisted that he is innocent of all of them. His supporters point to exactly the vulnerability his lawyers raised at trial, arguing that a man who functions mentally like a child, and who once confessed to a death that DNA proved was not his, cannot be relied upon to have confessed truthfully to the others either. Prosecutors counter that the physical evidence and the circumstances of his own family's discovery leave little room for doubt. The official count stands at 5 lives taken, reduced from the 6 he was originally convicted of, after the death that was never his was traced to another hand. That other hand would surface again before this story is done, because the DNA that cleared Gerald's of one death pointed straight at a far larger pattern still unfolding in the same part of the city. It is one of the reasons his case matters beyond its own body count, because it was the first crack in a wall that would eventually reveal just how much had gone wrong on those streets, and how many separate men had been mistaken for one another. But before returning to Chicago, the trail leads several hours south, to a small city near the Mississippi River, where a different kind of horror had been circling a single house on a single street. Lorenzo Fain. Over roughly 4 years in the early 1990s, a series of young people vanished from a single neighborhood in the East St. Louis area, nearly all of them living within walking distance of the same house. Investigators kept returning to that same small radius, and eventually the trail led them to the man staying inside it. What ultimately kept him off death row for his first conviction was not a shortage of evidence. It was a single person sitting in a jury box. The man was Lorenzo Fain, born in Milwaukee on April 2nd, 1971. Testing over the years placed his intelligence in a borderline range, and in 1989 he moved to East St. Louis, Illinois, to live with his grandmother. It was in the blocks around her home that the disappearances began, and it was those same blocks that would eventually give him away. Every one of his young victims lived only a short distance from where he was staying, a detail that would prove central once investigators finally stepped back and looked at the map. Between 1989 and 1993, Fain took the lives of 5 young people in the East St. Louis and Centerville area. Out of respect for who they were, and because they were children and teenagers, their names and details are left where they belong, with their families. What matters for the story is the pattern, and the pattern was chillingly tight. These were young lives taken close to home, one after another, in a community that had every reason to feel it was under siege and no idea yet who was responsible. The record includes further offenses that this account will not detail. The focus here stays on the facts the case established and the response it eventually drew. For a time, the neighborhood absorbed the losses without a suspect, and each case was investigated on its own. The turning point came when investigators finally stepped back and stopped treating the deaths as unrelated, asking instead what they all had in common. What they had in common was geography. The victims had all lived and been found within the same tight cluster of streets, and at the center of that cluster sat one address and one man. The arrest came on July 24th, 1993, in connection with one of the deaths, a case in which an apartment had been set on fire and witnesses were able to identify him leaving the area. Once he was in custody, Fain confessed to 4 more of the deaths, filling in a picture the community had feared but could not yet prove. In a matter of days, 5 separate open cases collapsed into one name, and the small radius that had puzzled detectives suddenly made terrible sense. The man had never had to travel far, because the danger had always been standing among them. How does a case this overwhelming end in anything other than the harshest sentence the law allows? In Fain's case, the answer came down to a single juror. Early in 1994, he was convicted in the first of the deaths, and the jury recommended a death sentence. But under Illinois law, that decision had to be unanimous. One holdout refused to sign on, and by rule the sentence became life without the possibility of parole. It is a quiet feature of the system that rarely draws attention. In a state that required every juror to agree before it could impose a death sentence, one holdout was enough to take execution off the table. And that is exactly what happened here. Prosecutors were far from finished, Because the deaths had occurred across more than one jurisdiction, the case could be tried more than once, and the state intended to use every count it had. Fain was later tried in St. Clair County before Judge James Donovan for 4 more of the deaths, and this time the jury reached the verdict prosecutors had sought, with no lone holdout to stop it. In 2001, Fain was sentenced to death. For a brief window, it appeared the state would finally carry out the punishment that a single juror had blocked years earlier, and the families who had endured a second trial believed they had, at last, an answer that would hold. Then came the same reversal that reshaped so many of these cases. On January 11, 2003, Governor Ryan's clemency commuted Fain's death sentence, along with everyone else's, to life without parole. Whatever the courts downstate had decided, the outcome was now identical to the rest, and to the very sentence that single holdout had forced the first time around. He would serve a life term until his death, with no execution date attached to it. The families who had sat through 2 separate trials to reach a death verdict watched that result dissolve with the stroke of a departing governor's pen. The story did not fully close there. In September of 2009, DNA evidence connected Fain to yet another death, that of a 32-year-old woman named Rita Scott, who had lost her life in Milwaukee back in 1989 before he ever moved to Illinois. He confessed to that death as well, extending his known history back to the city where he was born. In the same period, DNA testing cleared him of a separate death he had once been linked to, a reminder that the same science could both widen a case and correct it. Fain's case shares an uncomfortable feature with Gerald's, one that runs through more of these files than most viewers would expect. Here, too, was a man whose intelligence testing placed him in a borderline range, whose lawyers leaned on that limitation, and whose fate was ultimately settled the same way as the others, by the governor's decision to empty the state's death row all at once. Whatever a court might have concluded about whether such a man should be executed, the clemency made the question moot for him as well. As of today, Lorenzo Fain remains alive and incarcerated at Menard, serving life without parole. Counting the young lives lost around his grandmother's neighborhood and the earlier death in Milwaukee, he is tied to 6 deaths in all, spread across 2 states and more than a decade. The thread that surfaced in Fain's later years, DNA quietly revealing the truth long after the fact, ran through nearly every case in this story. And nowhere did it tie more knots at once than back in the abandoned buildings of Chicago's South Side, where a single genetic profile would connect one man to a toll larger than any other name we have reached so far. Andre Crawford. For most of the 1990s, someone was taking the lives of women in the abandoned buildings of Chicago's South Side, and for years the case stayed cold. When police finally made an arrest, the man did not just confess to his own crimes. His statement cleared a person who had been wrongly accused, and it unraveled part of another killer's conviction. By the time he stood before a jury, the count attached to his name had reached 11. His name was Andre Crawford, born in Chicago on March 20, 1962. His father left after he was born. His mother was neglectful and abusive, and he spent time in foster care, where he later said he suffered further mistreatment. Out of that broken beginning came a man who would move through the New City and Inglewood neighborhoods for years, all but invisible to the people around him, blending into a landscape of vacant lots and boarded-up buildings that no one was watching closely. Between 1993 and 1999, Crawford took the lives of 11 women, among them Evandre Harris, Patricia Dunn, Angel Shateen, and Rhonda King. Like the victims in Gerald's case, they were women struggling with addiction in a part of the city where their disappearances drew little notice and even less urgency. He lured them into empty buildings, ended their lives, and, in a detail that stayed with investigators long afterward, took and sold the shoes off some of his victims. A 12th woman, attacked around Thanksgiving of 1997, survived, and she would later become the living witness who could point directly at him. For years, though, no name attached to the pattern. The deaths were spread across time. The victims lived at the margins, and the neighborhood had long since learned that some cases simply went unsolved. What finally changed everything was a laboratory. As DNA testing matured, investigators were able to link a string of these separate deaths to one genetic profile, proving that a single person had been responsible for cases that had long been treated as unrelated. For the first time, investigators could prove a connection that had eluded them for years. Then, on January 28, 2000, a tip combined with that DNA match finally brought Crawford in. What followed was extraordinary, even by the standards of these cases. Over 3 days, on videotape, he confessed in detail to the deaths, walking investigators through a span of crimes that had gone unsolved for the better part of a decade, describing scenes only the person responsible could have known. It was one of the most complete confessions the detectives on the case had ever taken, and it did far more than close his own file. What is the true cost of a case that sits cold for years while a man keeps returning to the same few blocks? In Crawford's case, that cost was measured in more than the lives he took. His confession also freed a man named Derek Fluellen, whose own coerced statement had wrongly tied him to one of the deaths, and whose charges were dropped once the truth came out. And it was Crawford's DNA and his account that vacated one of Hubert Gerald's convictions, the death of Rhonda King, correcting a case that had put the wrong man's name on a victim years earlier. One man's confession, however monstrous its subject, untangled 2 separate miscarriages of justice at once, the kind of correction that almost never happens in a single stroke. The legal proceedings themselves came unusually late. His trial did not begin until November of 2009 in Cook County, before Judge Evelyn Clay, nearly a decade after his arrest, and even longer after his first crimes. The delay meant the case reached a courtroom in a very different Illinois than the one that had condemned men like Brisbane and Gerald's. The state was moving steadily away from capital punishment, and would formally abolish it not long after. On December 10, 2009, after roughly a month in court, the jury convicted him on all counts. Unlike the men swept up in Governor Ryan's clemency years earlier, Crawford's fate was decided directly by that jury, and Illinois law required that any death sentence be unanimous. The jurors did not agree on death. On December 18, 2009, he was sentenced to life without the possibility of parole and sent to Menard, joining the other men whose crimes had terrified the state. It is worth sitting with the arithmetic of that outcome for a moment. 11 lives, a decade of fear across the South Side, and the sentence that closed it was the same one the men before him had received only because a governor had intervened. In Crawford's case, no clemency had been needed, because by the time his trial arrived, the state had already stopped seeking the death penalty in cases like his. There is a harder truth underneath the numbers, and it deserves to be said plainly. The reason Crawford was able to take 11 lives over 6 years was that his victims were the people the city was least likely to look for. They were women whose names rarely made the news while they were alive, whose disappearances were logged and set aside, whose families often could not command the attention a case like this should have drawn from the start. In these neighborhoods, a pattern that should have set off alarms was instead allowed to keep growing for years before anyone in authority treated it as a single urgent case. That neglect was the shadow Crawford operated in, and it is part of why he lasted as long as he did. Andre Crawford's story is the one on this list that has already reached its final chapter. On March 18, 2017, he died at Menard of liver cancer at the age of 54, just 2 days before what would have been his 55th birthday. His passing drew almost no attention at the time and was reported only later, a quiet end for a case that had once frozen an entire side of the city. There was no announcement, no final reckoning in a courtroom, only a name removed from a custody roster. He is held responsible for 11 lives, the highest confirmed toll of anyone we have covered so far, and the only one among these 4 whose story ended with a death certificate signed inside the same walls that had once held him. The 4 men so far each worked in the shadows, their crimes hidden by distance, by neglect, or by the sheer number of years it took anyone to connect them to a single hand. The names still ahead did not all stay so hidden, but nearly every one of them would end up bound to the same handful of decisions about who deserved to live and whom the state would finally choose to spare. If you're liking this video and you're not subscribed yet, now's the time. We drop new cases every day. Subscribe so you don't miss the next one. Milton Johnson. For one long summer, an entire Illinois county was afraid to leave the house. Between late June and late August of 1983, people around Joliet were being attacked seemingly at random, on back roads, in parked cars, inside a small shop, with no pattern anyone could see and no name anyone could put to it. Residents began buying guns and ammunition to protect themselves, and the man behind it had been released from prison early, only months before the first of the deaths. His name was Milton Johnson, born in Joliet on May 15, 1950. Little is recorded about his early years, but his adult history took shape in 1970, when, at 19, he was convicted in a violent attack on a Joliet woman during a burglary and sentenced to 25 years. By any ordinary calculation, he should have remained behind bars until the middle of the 1980s. Instead, on March 10, 1983, he was released early on parole, moved back in with family in the Joliet area, and within a matter of months, the county around him began to bury its dead. The people he harmed had almost nothing in common. There was a young man on a rural road south of Joliet, 18-year-old Anthony Hackett, and the young woman with him, who was gravely hurt but survived. There were 2 police officers who answered a call and did not come home. And there were 4 women going about an ordinary workday inside a ceramic shop on East Cass Street in Joliet. Among them, the oldest of his victims, 75-year-old Anna Ryan. They shared only one thing, which was that each of them had crossed Milton Johnson's path during those 2 months. The span of it was staggering. Between June 25th and August 25th of 1983, authorities came to believe Johnson had taken as many as 14 lives across Will County, though only a portion of those could ever be brought into a courtroom. Some victims were attacked on lonely stretches of road, ambushed as they sat in their vehicles. Others were harmed inside businesses in broad daylight. The attacks came without warning and without motive, which is exactly what made them so difficult to stop. Because he chose strangers, there was no relationship for detectives to trace, no grudge to follow back to its source. Law enforcement flooded the county, chasing a pattern that seemed to have no center, while ordinary families locked their doors and waited for a summer that would not end. The timing of the attacks gave him his names in the local press. Many of them fell on weekends or in the early morning hours, and so he came to be called, at different points, the weekend murderer and the morning murderer, labels that captured just how routine the terror had started to feel. 2 of the lives he took were those of police officers, lost after they arrived to help at the scene of an earlier attack, a detail that turned an already frantic investigation into something closer to a war footing across the whole of Will County. The break, when it came, was almost mundane. Officers had been fielding repeated complaints about the driver of a dark pickup truck harassing women around Joliet, and those complaints slowly narrowed toward Johnson. The young woman who had lived through the roadside attack proved able to identify the man who had harmed her. On March 9, 1984, Johnson was arrested, and after nearly a year of dread, the summer of fear finally had a face. That he had been a paroled man, released years ahead of schedule, only sharpened the public anger. A system that was supposed to keep him locked away had instead turned him loose right before the killings began. How do you build a case against a man whose victims were chosen at random, with almost nothing tying one scene to the next? The state answered that question by narrowing its focus. Will County State's Attorney Edward Petka chose the strongest evidence available, centered on the roadside case and the ceramics shop case, and built the prosecution around those rather than trying to charge every death at once. In an unusual and unsettling turn, Johnson chose to represent himself at the trial for the shop, cross-examining witnesses in the very proceeding that would help send him to death row. On January 28, 1986, he was convicted, and for a total of 5 of the deaths, he was sentenced to die. Over the years that followed, his appeals moved through the Illinois Supreme Court more than once, and the conviction survived each challenge. Even a later round of DNA testing, which some hoped might reshape the case, failed to clear him in the 1983 crimes. The verdicts held, and Johnson settled into the long routine of a condemned man. Then his sentence changed the way so many others in this account did. On January 11, 2003, Governor George Ryan's blanket clemency swept Johnson's death sentence into life without the possibility of parole, folding the most notorious name ever to come out of Joliet into the same commutation that spared everyone else on the state's death row. For the families who had waited more than 2 decades for an execution date, the reduction landed as one more injury piled onto the first. Johnson was moved into the general population of the state's prison system, and in time, held at Menard, hundreds of miles from the county he had terrorized. In Joliet, his name kept its weight for decades afterward, spoken as a marker of the one summer that changed how the town felt about its own streets. As of the most recent records, Milton Johnson's story has reached its end. He died at Menard Correctional Center on May 16, 2025, at the age of 75, one day after his birthday, still serving the life term his death sentence had become. By the time he passed, the death penalty he had once been given no longer existed in Illinois at all. He is remembered still as the worst thing ever to happen to Joliet, a man who for one summer turned an ordinary county into a place where people watched the road behind them. Johnson terrorized a whole county precisely because his attacks were public and everywhere at once, impossible to predict. The next man on this list worked in the opposite direction, staying so far out of sight that the people closest to him never suspected a thing. Kevin Taylor. By day, he cooked at a well-known restaurant on one of Chicago's busiest avenues, then went home to a girlfriend and 2 children, looking like any other young father trying to build a life. But across one summer, 4 women were being strangled on the city's north side, and the man who had been with them last was that same cook, clocking in for his shift the next morning. What finally exposed the double life was a single card with his name printed on it. Kevin Taylor was born in Chicago on June 11, 1974. Both of his parents spent time behind bars, and he grew up passed between a string of foster homes, never settling anywhere for long. His own record began early, with a burglary conviction in 1993 that sent him away for 4 years, followed by a weapons conviction later in the decade. By the end of 2000, though, he had found steady work as a cook at the Cheesecake Factory on North Michigan Avenue, one of the most visible restaurants in the city. By the summer of 2001, he was living with his girlfriend and his 2 children downstate in Edwardsville, commuting into a life that, from the outside, looked like a man finally getting himself together. Nothing in that daily routine hinted at what he did in his off hours. He held a job, kept a household, and moved through the city the way countless other working men did, which is precisely why the pattern took so long for anyone to see. A man with a time card and a family waiting at home was not the figure investigators pictured when they tried to imagine whoever was leaving women dead across the North Side. The women he targeted were among the most overlooked in the city. Ola Mae Wallace, Diane Jordan, Cynthia Hulk, and Bernadine Blunt were all working the North Side, all struggling at the margins of Chicago, the kind of women whose disappearances a large city can absorb without ever quite noticing. Each was in her late 30s or early 40s, and each, in the last hours of her life, crossed paths with a man who seemed entirely ordinary right up until the moment she did not walk away. Between late June and the middle of August of 2001, Taylor took the lives of those 4 women, each after soliciting her, each in the same quiet, deliberate manner. He would approach them as a paying customer, and what began as a transaction ended with a woman strangled and left behind. The body of Cynthia Hulk was found discarded in a garbage container near the corner of Clark and Division, one of the busiest intersections on the North Side, a place thousands of people passed every day without a second glance. For a time, the deaths sat entirely unconnected, 4 separate tragedies among the city's most vulnerable, none of them commanding the kind of urgent, coordinated response a case like this should have drawn from the beginning. Then a 5th woman survived an encounter with him and lived to describe exactly who had attacked her and how. Her account, combined with the physical evidence gathered from the earlier scenes, began to draw the separate cases into a single picture. When investigators placed Taylor at the center of that picture, part of what tied him to it was strikingly ordinary, a work time card that helped establish where he had been and when. On August 21, 2001, only days after the last of the deaths, he was arrested, and the quiet summer of strangulations on the North Side came to an end. The man who had hidden behind a uniform and a commute was, at last, in custody. How does a man conceal 4 deaths behind a time clock and a family dinner table? The court spent years answering that. In January of 2006, Taylor stood trial in Cook County for the death of Cynthia Hulk, and a jury convicted him of taking her life. On June 16, 2006, Judge Fred Surya sentenced him to 50 years in prison, weighing his troubled childhood and years in foster care against the sheer gravity of what he had done, and stopping just short of the maximum. Rather than face separate trials for the rest, Taylor pleaded guilty that August in the 3 remaining deaths and to an attempt on the life of the woman who had survived, drawing multiple life terms stacked on top of the sentence he already carried. There would be no walking out. Unlike so many of the men in this account, no governor's decision ever touched his fate, because his crimes reached a courtroom only after Illinois had already emptied its death row. The sentence that would hold him for the rest of his life came straight from the bench, with no clemency to soften it and none required. The arithmetic of that sentencing told its own story. 50 years for the first death, then a stack of life terms for the others. A total built to guarantee that a man not yet middle-aged would never again see the outside of a prison wall. Had his crimes been tried a decade earlier, he might well have faced the death chamber. By the time a courtroom finally weighed them, that punishment had already passed out of Illinois law altogether. As of today, Kevin Taylor remains alive and incarcerated at Menard, serving out those life terms. His confirmed count stands at 4, though the fifth woman, the one who lived, remains the reason any of it was ever solved. In a case built on victims a city had trained itself to overlook, she became the single witness who could not be set aside, the living proof that turned four cold files into one closed one. Without her, the cook with the ordinary life might have kept both of his lives running side by side for far longer. By the time he was caught, he had kept that split existence going for the better part of a year, and the people who shared his home downstate had no idea what he did on the nights he was away. Taylor's undoing came down to a surviving witness and a scrap of paper, the kind of break that can take years to arrive, and sometimes never does at all. To reach a case that waited even longer for its full reckoning, the trail runs south and back in time, to the streets of East St. Louis at the close of the 1970s. Andre Jones. This is the oldest case on the list, and in some ways the most tangled. A man whose criminal record began before he was even a teenager would later confess to a series of deaths no one had ever charged him with, including one he claimed to have carried out when he was just 14 years old. By the time investigators finished sorting out what was real and what could actually be proven, the true reach of his violence had stretched well beyond the 3 deaths that first sent him to death row. Andre Vernell Jones was born in East St. Louis on July 22, 1956. His criminal history reportedly began at the age of 12 with purse snatching and grew steadily from there into theft, shoplifting, armed robbery, and eventually an attempt on another person's life. He was, in the language of the courts that would later handle him, a career offender long before he became a killer. At the time of the crimes that would define him, he was out on parole, having served only about 4 years of a sentence for armed robbery before the state released him. Whatever second chance that freedom was meant to represent, he returned instead to the pattern he already knew. East St. Louis in those years was a difficult place to police, and Jones was not the only killer working its streets. His crimes unfolded in the same region and the same stretch of time as those of other men whose names filled the same local headlines. That backdrop mattered because it left investigators a great deal of violence to sort through and a real risk that the work of one man could blur into the work of another. On the last day of April in 1979, Jones and an accomplice named Freddie Tiller took 3 lives across East St. Louis in the span of a single afternoon. The first was 63-year-old Richard Stoltz, a veteran of the Second World War, robbed and fatally shot as he stacked bricks in the back of a pickup truck. The next was 23-year-old Samuel Nersessian, the owner of a dry cleaning shop the 2 men decided to rob. The last was 21-year-old Deborah Brown, a letter carrier who had the terrible misfortune of walking into that shop while the robbery was still underway and became a witness the men would not leave behind. Jones's own girlfriend was present for part of the afternoon and would later testify about what she had seen, becoming one of the state's most important voices against him. The 2 men were arrested days later, on May 4, 1979. But the fuller and stranger picture of Andre Jones did not emerge until afterward, in the confessions he began to volunteer. In 1980, he admitted to a triple killing dating back to 1971, when he said he had been only 14. 3 men who he claimed had failed to pay him money over drugs. An officer at the time, the story went, had dismissed the account outright, unable to believe that someone so young could have done such a thing on his own. Jones also confessed to the deaths of an elderly couple, Michael and Dora Wallace, taken in their own home in late 1978. He was never tried for any of those additional cases, and some of what he said could never be independently confirmed, but together the confessions pushed the number of lives investigators tied to him to somewhere between 5 and 8. What do you do with a man who keeps confessing to crimes the system was never able to pin on him? The law, at least, moved decisively on the cases it could actually prove. On August 23, 1979, Jones pleaded guilty in all three of the East St. Louis deaths and was sentenced to death. His appeals wound through the courts across the following 2 decades, reaching the federal level as well as the Illinois Supreme Court, and each time the conviction stood firm. His accomplice took a very different path through the system. Tiller's death sentence was overturned on appeal, on the reasoning that it had not been proven he intended for the victims to die. And after a long series of hearings, he was resentenced to a lengthy term, and many years later, released from prison altogether. Jones, whose own hand the courts never doubted, stayed exactly where he was on death row. Across those years, his case generated a long paper trail of federal petitions and state reviews, each one testing the guilty plea he had entered, and each one leaving it firmly intact. The courts that examined his file were not troubled by any question of who had done the shooting. The evidence and his own admissions pointed in only one direction. The confessions he had given and the testimony against him were more than the courts needed. The only real uncertainty left in his case lay in the crimes he claimed, but was never charged with. The clemency that had already reshaped so many of these cases reached Jones as well. On January 11, 2003, Governor Ryan commuted his death sentence to life without parole. The decision drew open fury from the family of at least one of his victims. One of Richard Stoltz's daughters spoke with raw bitterness about the mercy being shown to the man who had taken her father, wishing aloud that the governor and the killer might one day keep each other company somewhere far worse than prison. For the families downstate, the commutation tore open a wound that a death sentence had, in their minds, finally begun to close. As of today, Andre Jones remains alive and incarcerated at Menard, serving life without parole. He stands convicted in the 3 East St. Louis deaths and is suspected in as many as 5 more that were never brought to trial. A history that reaches back into his own childhood and stretches across the better part of a decade. His is the case on this list whose full extent may never truly be known, because so much of it rests on confessions the courts were never able to test, statements that widened his story without ever quite closing it. Jones acted alongside a partner, but the violence in the cases that convicted him was his own. The final name on this list stands apart from everyone before it, because the crime at its center was not the work of a single person acting alone, and because its victims included the youngest that this account has reached. Fidel Caffey. The last case is the one many people in Illinois have never been able to forget, and the one this account will handle with the most care. In the autumn of 1995, an expectant mother and members of her family lost their lives in a crime that shocked the state and drew national attention. 3 people were ultimately convicted in connection with it, and the man at the center of the prosecution has insisted, from that time to this, that he was never there at all. The events took place on November 16, 1995, in Addison, a suburb west of Chicago. Deborah Evans, a young mother who was expecting a child, lost her life inside her own apartment. Her newborn was taken from the scene and, remarkably, was recovered alive the following day. 2 of her other children did not survive, while the youngest was left physically unharmed. The details of what happened were among the most disturbing in the state's modern history, and this account will not rehearse them. What matters here is the family that was shattered and the long legal reckoning that followed for the people accused of shattering it. Deborah Evans was, before everything else, a mother raising her children in a quiet DuPage County suburb, the kind of person whose ordinary life makes the loss all the harder to absorb. In the days and weeks after, the surviving newborn became, in a painful sense, the center of the entire case. An infant recovered from the very people accused of the crime and returned to what was left of a family that had been torn apart in a single night. The investigation moved quickly. Police arrested 3 people: Deborah's former boyfriend, Laverne Ward, his cousin, Jacqueline Williams, and Williams's boyfriend, Fidel Caffey. Williams was found in possession of the surviving infant the day after the crime, a discovery that began to unravel the rest of the case almost immediately. The 3 were charged together but tried separately, each defendant facing his or her own jury, each case building toward its own verdict and its own sentence. The other 2 defendants met their own reckonings in those separate courtrooms. Jacqueline Williams was herself convicted and condemned, her death sentence later reduced in the same wave of clemency that would eventually reach Caffey, while Laverne Ward was convicted for his own role in the events of that night. 3 separate juries, 3 separate trials, and yet the 3 cases stayed bound together by the single night that produced them and by the surviving infant at the heart of all of it. It was a prosecution that stretched across years and produced one of the most closely watched sets of trials the county had ever seen. How does a case this painful move through a courtroom without ever losing sight of the people at its center? For Fidel Caffey, the legal road has been long and bitterly contested. In 1999, a DuPage County jury convicted him in the deaths of Deborah Evans and 2 of her children, along with aggravated kidnapping, and he was sentenced to death, with an additional consecutive term of 30 years attached to the kidnapping conviction. The Illinois Supreme Court affirmed that conviction in October of 2001, rejecting the challenges his lawyers raised on appeal. Then, on January 11, 2003, Governor Ryan's clemency reduced his death sentence to life without the possibility of parole, placing Caffey among the many whose ultimate fate was decided by the governor's pen rather than by any execution date the state might have set. But Caffey's case did not rest there, and this is where it grows genuinely complicated. Years after his conviction, a federal judge granted him an evidentiary hearing following serious questions about the fairness of his trial. Among the allegations were claims that a county prosecutor had improper dealings with a key witness, and that arrangements offered to other witnesses had never been disclosed to the defense. The kind of hidden problems that can quietly undermine an entire verdict. The claims reached into the conduct of the DuPage County State's Attorney's Office itself, an office that in those years faced hard public questions about how it had handled several of its highest-profile prosecutions. For a period, it genuinely appeared that the door to a new trial had cracked open. His post-conviction attorney went so far as to say publicly that he believed Caffey might well be innocent of the crime that had put him away. The hearing gave those claims a formal airing they had never received. In 2015, however, a federal appeals court affirmed the denial of his petition, leaving both his conviction and his life sentence firmly in place. The court's ruling was detailed and unsparing, working through each of Caffey's constitutional claims in turn and rejecting them one by one, from the handling of certain statements at trial to the alleged failures to share information with the defense. For his supporters, the decision closed a door they had spent years trying to hold open. For the prosecution, and for what remained of the Evans family, it confirmed what a jury had already concluded more than a decade before. For a case that had drawn national coverage from the night it happened, the appellate record grew to hundreds of pages, each ruling revisiting evidence that most of the public had long since stopped following. Through every stage of it, Caffey has never once wavered from his claim that he had no part in what happened that November night. As of today, Fidel Caffey remains alive and incarcerated in Illinois, serving life without parole and still maintaining his innocence to anyone who will listen. The child recovered alive that day, the one who sat at the very center of everything, was raised away from the public eye, and, by later accounts, has grown up and lived a private life, far removed from the events that marked its first hours. The case itself has resurfaced periodically in the years since, in appeals, in news coverage, and in the long-running debate over capital punishment that it helped to inform. Whether the right man is serving that sentence is a question the courts have answered one way, and CAFI has answered another, and for some who have followed the case across the decades, it remains, even now, genuinely unsettled. 8 names, 1 prison in the small town of Chester, and a single decision in 2003 that quietly rewrote the ending of nearly every one of these stories. Whether that decision was an act of conscience or a failure of justice is something people in Illinois still argue about, and we will leave that judgment where it belongs, with you. Thanks for watching. Click here for the next video.